This is a part code report in the matter of Optis Cellular Technology LLC and Apple Retail UK Ltd.
Mr. Senator, may it please the Court, roadmap for this morning. First, I'll make brief submissions to conclude on grounds 2 to 4. Second, I'll cover grounds 5 to 9, the ones that accept the basic framework of the judge's approach but say he made a series of appealable errors along the way. Third, I'll deal briskly with Optis's singular ground of appeal, which is the apparent bias or anchoring complaint. And fourth, finally, I'll deal with 2 points on the other licence terms, non-money, which it seems to us it remains necessary for this court to consider. I must aim to get through this somehow by somewhere between 12:15 and 12:30, because I then pass the baton to Mr. Mercer. He's dealing with the issue of the parallel US proceedings, which is as important as it's genuinely interesting, and he has impressed on me that he will need at least a couple of hours to get through that. And Mr. Speck has emphasised that he's entitled to around 25 minutes, I think. He's now saying 35 minutes for a reply. We've agreed 35 minutes for a reply before the end of the day, so one must ensure there's time for that too. If time permits, I'll deal with the answers to the different points raised by my Lord Justice Arnold last week at the end of our mutual submissions. But if time runs out, if the court is willing, I'll hand up a note or deal with it subsequently in writing. On housekeeping, there's one housekeeping point. If the court would please open the judgment and go to page 307, paragraph 149. That's page 302, I should have said. Paragraph 149. The court will see that there are, in paragraph 149, describing the structure of Optis, 3 companies that are mentioned as having a stake in the revenues generated by Optis. The ones mentioned are Ericsson, LG and Panasonic. If I mentioned any other company in opening, I misspoke.
Yeah.
So
just on that question, since you draw attention to this paragraph, the paragraph contains within it, at a point we can see, a reference to a company which is highlighted in blue, therefore I won't say it, but one can see that underneath the highlighting, it's crossed through, which I assume means that it's crossed through in the even before the blue has been applied to it, as it were. Are you able to explain that?
Yes, I'm told that is correct, that that entity does not have a continuing stake in the financial fortunes of Optis.
But why is it there at all? I mean, it seems very odd. I mean, is this some kind of typographical artifact? It's not intended to be there at all.
So no, I have to be careful, but it was an original contributor. It no longer is one, as I understand it, that has.
My Lords, if I may, it was in error in the original draft judgment, and at one of the consequentials hearing, solicitors representing the struck-through party made representations to the court that it was erroneous, and the judge accepted that it was erroneous and moved to delete it. And in the markup, it's just been left as struck-through. But that
So you think the intention was actually to delete it?
Exactly.
Yeah. Thank you.
I'm grateful. So, final points on grounds 2 to 4. The issue I was covering at the end of Friday was Optis's argument that in view of the matters which Mr. Speck's referred to, it is to be expected that all the Apple comparables would be artificially depressed and therefore unreliable. And he laid stress in particular on the statements on Apple's website that a licensee is ultimately entitled to require validity and essentiality to be proved on a patent by patent basis, and also Apple's practice in negotiations of not formally or openly admitting that a patent is valid and infringed, even though on the other side of the table the SEP licensors too may not formally admit that any patent is invalid or not infringed. And the gist of my response, you'll recall at the end of the day, was that the judge received evidence on the full commercial context of negotiations with all the licensors, and he formed the impression that the rates were not artificially depressed through such behaviour, and that there was hard bargaining on both sides. Those were findings of fact. The judge was shown that the pattern, the typical pattern, was for a sample chosen by the licensor to be tested, allowing both sides to gain an appreciation of portfolio strength and the risks, while in parallel, substantial offers for a global portfolio deal are made by, in this case, Apple. And you saw on Friday short extracts from the cross-examination of one of the three Apple negotiated witnesses, Mr. Ankenbrandt. Now, in his address, Mr. Speck spent quite a bit of time showing the court two internal slide presentations from Apple, which you'll recall set out options and thinking on Apple's part around the year 2014. And he told the court that this material was cross-examined on, but he didn't go to it other than to say that Miss Muse of Apple struggled. I don't have the time to take this court through that cross-examination, even if it were appropriate. But on our side of the courtroom, and as revealed by the judge's final finding about the nature of negotiations on the Apple licenses, it wasn't, we say, Miss Muse who was struggling. But I do need, however, to give this court just two brief references to that cross-examination, because they also reinforce one of the main points I was making at the end of Friday. And if the court would please take up supplemental bundle 1 and go in it to tab 21, where there is the collection of transcript of cross-examination extracts. Go inside that to page 279. What you have here is a part of Mr. Speck's cross-examination, in which he went through all of these slides and point by point on each slide, which really begins back at page 272 in the bundle, in the top right-hand tile. And may I say at the outset, the court's welcome to read it all to get the overall gist. I'm not seeking to misrepresent this. But in view of the time, if you pick it up at 279 and look at the bottom right-hand tile, which is manuscript 761, you see a few key things. The first, from line 9, you see Miss Muse telling the cross-examiner that the slide is only a description of a range of approaches in licensing negotiations and the pros and cons. If you turn over to page 762 of the manuscript and you pick it up at line 22 or so, at the bottom of the page, line 24, you see the question. Let's look at the next pro. The questioner says, the pro is establish rates for use in policy setting and so forth. That's the point. Opportunistically entering into a license that's favourable to you so that you can point to it in each of those three arenas, is it not? And the answer that's given is important. She says, I don't think you opportunistically license 50% of the LTE market and it not be real. Then on the right-hand side of that page, as you're looking at it, at the bottom of the top manuscript tile, page 764, line 24, the questioner asks again, you don't agree that what you are going to do is selectively filter which licenses to enter into for that purpose. And he gets the answer, like I said, I mean, you don't license the likes of Ericsson and Interdigital and Nokia at cut rate prices. And I draw attention just to that because there's a degree of bewilderment which you can see shining off the page in that response. The point made connects with the finding that was reached by Mr. Justice Meller on one of these exact licenses in his parallel case, the Lenovo and Interdigital.
How can we rely on that?
I'm not asking you to rely on it. Again, Hollington and Hewthorne's a finding, but as a data point, it's nonetheless, I say, appropriate for this court to observe that he said about the same license, it may represent an upper bound. Doubts that it represents a depressed rate. So that
Seems to me to be relying on his finding.
it's drawing attention, my lord, to that in connection with the submission that's made here, but not seeking to say that he must be right, but merely that this court, in considering its, or the trial court and this court, in considering their own approaches, can take that view and look at how other courts have approached things in other FRAND cases. And in that light way, we say that that is permissible in this sphere. So that's the main point to add today to my existing submissions about why the judge reached a reasonable conclusion on this matter, one that a judge could properly have reached on the evidence. His findings, which for your note are most conveniently crystallised, don't need to go there, at paragraph 417 Roman 3 in the judgment, it's on page 451, those are sound. Now, there is one final point which does need to be addressed, and this one also provides a bridge to considering the next topic, the allegations of errors of implementation by the judge of his method. And this is the response to Mr. Speck's argument that Apple's stated approach to negotiations, unashamedly, is to take advantage of less economically powerful undertakings. And he got that idea from our position statement for the trial below, in which Apple listed out factors that had led it on occasion, looking across the comparables, to paying a higher price for a patent license than its internal methodology would suggest at first sight, and also factors that on occasion led to it paying a lower price than its internal methodology would have suggested. One of those factors concerned a downturn in a particular licensor's economic fortunes at the time of negotiations, leading it to being willing to drop its demands during that negotiation process. This was not in the least an instruction manual or comment related to small licensors in general. It was a specific point that we put into the position statement as a matter of scrupulousness to the court to explain something in one particular instance of a big player when we reviewed the disclosure. Now, I can't name that big player, but may I just show you what this is based on? Is that hand up? I've got a hand up. Yes. It's coming around. Can I have a copy too, please? So the court has heard of two of the three negotiator witnesses who gave evidence at the trial. The main one was Miss Heather Muse. Then there were also Mr. Brian Ankenbrandt and this gentleman, his name is David Rockenauer. He was the main negotiator for Apple in relation to a few of the licenses. And if you go to the third page of this, which is internal page 5, I'm afraid this is all in blue. The relevant paragraphs are 16 to 18. If you cast your eye over it, you see there the specific circumstances of that case and who the other party was.
Should we just do that? Read paragraph 16.
Please, yes, please do.
Yes.
So, my lords, this is a short point. You see the specific circumstances. You see that the licence sum, in the end, covered a range of valuable considerations apart from the licence to the cellular SEPs, something that was a feature of quite a few of the big major counterparties in these cases. The circumstances that led this particular player to reduce its offer in the negotiations was noted by Apple. My submission is simply that this is not part of a cynical playbook to pay licensors less than the portfolio is worth. And it was understandably magnified in submissions from the other side that that was the context for the point that was made by Apple in its position statement. My lords, that disposes, that's all I have to say on the allegation of systematic holdout. The remaining limbs of grounds 2 and 3 are the contentions that the Google and Qualcomm licenses were clean. They were reliable data points. Those should have provided the basis for an unpacking exercise to get to a FRAND rate. Now, I've largely covered this already in my existing submissions last week. For Google, I addressed the unreliability of the Google data point last Thursday. To summarise the points, number one, it's not a licence to the same portfolio as is at issue in these proceedings. It's got the Ericsson patents in it. It doesn't have the Samsung patents. Number two, it's a licence for a low lump sum in the same ballpark as litigation costs. Relates to a far smaller volume of device sales than Apple. Point three, that the unpacked rates derived from the Google license, which the judge looked at, and he used Optis's own expert figures in his reasoning. Those were seen to produce manifestly uneconomic rates on an ad valorem basis, and that is in the judgment on page 476. And the fourth point, which I spent some time on Thursday, that the new appendices relied on by Mr. Speck reveal the colossal sums which were implied by the Google license even more vividly. Now, Mr. Speck's response in this context was to query the enography data which is used for the establishing of what Optis's share of the stack is. That was data on declared essential patents. And if you recall, his point is, well, there's over-declaration with declared essential patents, and this is not reliable. The judge explained cogently why that would not be a factor to Optis's disadvantage in view of his finding that there was a lower than average, or at most average, quality of the Optis portfolio. I drew attention to that on Friday. That's paragraphs 108 and 109 of the judgment on page 205. There was no appeal against that part of the judge's conclusions. Indeed, in this appeal, the court will note that Optis is positively riding on the back of the inography scaling in order to justify the very large sums that it claims in what I've called its jackpot grounds. Thus, the dollar per unit figures that Optis itself is relying on in its skeleton argument in Annex 2, those are scaled using inography, and those figures feed into the enormous absolute sums of money that Optis says it's due to be paid by Apple in paragraph 9 of the skeleton.
Sorry, can I be clear? Is it your case that PA should be used instead? Because I think Mr. Speck would be entirely happy to use PA.
Oh, we're not saying that. No, we agree with inography too.
So what's the criticism?
The criticism is that whereas we're saying inography is a consistent tool for the scaling, he is saying, I'm happy to use it, and indeed I like using it, to generate these large
No, he doesn't like using it. He uses it because it's realistic recognition given the judge's approach. But he would prefer to use PA, but you say no to that.
Well, my lord, yes, let me be a little bit clearer, I apologise. What he is doing is he is using it in order to say that to this court that the right amount that his client should be awarded by Apple are these large sums, which we know about. When it comes to this part of the argument, which is why the Google license should be either heeded or not regarded, then he turns around and says, well, there's the over-declaration problem and inography doesn't work. So I'm merely drawing attention to that tension in this context. And your lord is absolutely right that there isn't an appeal against that part of the judge's reasoning in any event. So it's a form of what one nowadays calls cakeism. If one turns to Qualcomm, please go back to the main judgment at page 490. And if you look at Romans 6, at the foot of the page, just to refresh your memories, and over the next page at letters B and C, subparagraphs B and C on page 491, the point here is that the judge is concluding in clear terms that the evidence shows Qualcomm is a case of exercise of market power to achieve an unrepresentative rate, as well as commenting that the implied aggregate rate for the stack is severely out of line with all the other Apple comparables, being ones that he's found to be reliable in their own right. And our case is that that is an unimpeachable approach by the judge. Mr. Speck says, and he said orally it's also in his skeleton at paragraph 112, it was procedurally unfair to Optis for the judge to have found that Qualcomm was an unrepresentative exercise of market power in a context where he hadn't resolved the factual disputes between the parties about what happened in the Qualcomm-Apple negotiations that are described by our witness, Miss Muse, in her witness statement. The short answer is that not only did Mr. Speck entirely avoid any cross-examination of her about those points, there was none, the judge did not need to reach factual findings on what would have amounted in law to an abuse of a dominant position before simply deciding the key point. Am I going to treat the Qualcomm license as unrepresentative for the purpose of my comparables approach, owing to what seems to be a mismatch in market power? We say he was entitled to do that, the point that we debated on Thursday. And finally, in view of the reliance before this court on Google as the primary point, the single data point of importance, it does fall to be observed that the rates that the Google license produces on an unpacked basis are even more large when one considers where they sit even in relation to the Qualcomm rates which we say the judge was entitled to treat as an unrepresentative case. In other words, Google is an a fortiori case. The figures can be seen in Optis's appendix. I won't take you to it in the interest of time, Sup 4, tab 26, page 223, but it was the appendix that we went into in some detail on Thursday. So, my Lord, with that, and looking at the clock, I turn then to the grounds on the judge's approach and errors in implementation, grounds 5 to 9. And as you know, I'm not going to address ground 10, payment for the past. We do not contest that point before this court. What I do propose to do is to walk the court, if I may, briskly through the judge's methodology and pick up, in turn, each of the grounds which are said to amount to appealable errors. The starting point is to get an understanding of the judge's perspective about the significance of the information he had in front of him about individual licenses and whether or not it was safe to treat each of them individually as comparables in their own right. The evidence that he received in this case was that pretty well all the licenses, all of them, were not clean comparables, in the sense that the sums paid over by Apple were consideration not only for a set portfolio, but, as in the case of the one that you just looked at with the confidential blue, they reflected an assortment of other factors too, sometimes pulling in different directions. So, for example, we know that numerous licensors' patent portfolios include substantial, valuable, what's called NEP components, non-essential patent components, not just standard essential patents, and that is particularly the case for the larger counterparties. And in the case of the smaller licensors, where it's more confined to standard essential patents, it was explicit in some cases that the agreement was part of a larger deal of some kind, in particular where there was a wider type of relationship between Apple and that party. I'll give you some of the references. But to proceed with the line of argument, in other cases, you had either recent active participation by the licensor in the development of the standards, which could imply a strong but growing portfolio, or there was a static and shrinking portfolio, for example, because of patent expiries. And in one case in particular, there were very high historic royalty rates based on a previous licensing agreement being negotiated at a very early stage of the Apple iPhone, when Apple is a new entrant in 2007, and when threats of injunctions across the world were a particularly powerful concern for Apple. So that's the nature of the sort of evidence the judge receives about all of these. And he has witness statements from Apple talking about the circumstances of each license and showing him that there are warts and all for every single one of them. It was that evidence which led him to consider that it wasn't appropriate to treat any of the individual comparables as being independently reliable. And that includes these Apple licenses. And if on this you would please go in the judgment to page 387, you find an important point in his reasoning. It's his starting point. So that's page 387. And you'll see a bold heading at the top of the page, why the comparables are to be treated with caution. And if I may, it's most efficient if I simply ask the court first just to read paragraphs 288 to 291.
We'll do that.
So, Mel, perhaps the key sentence, and you see for yourselves the gist of his thinking about this, but the key sentence, probably the first sentence in paragraph 291, in my judgment, in this case at least, the comparables only have value if an inclusive approach is taken.
So that's a conclusion. What's the reason for it?
My lord, the reason for it is...
That the judge gives, I mean.
Well, he gives the reason here, which is a general point about the nature of these comparables and why they need to be treated with extreme caution. Mm-hmm. The reason, as we see it, is the point that I was making to the court a few minutes ago, that it was because each of these comparables has got issues with them in terms of the composition of what's going into it, what is negotiated, and what he calls, at another point in his judgment, the other factors. And his view is that whereas perhaps in other cases this problem didn't shine through to the same extent, here, because the evidence that he sees about these individual licenses shows him that there's complications in relation to all of them, the right way to approach it is that he's going to look at it on a sort of averaging basis where it all comes out in the wash. Yeah. That was the way that he...
Oh, no, I mean, you're quite right, that's the way he's done it, and I won't interrupt you, apart from asking you that question, thank you.
No, of course. So, I'm glad your lordship's raised it because, in a sense, and this may be what your lordship has in mind too, it helps answer the point that you raised with me at the end of last week about whether the judge's later table ought to be interpreted as meaning that each of the individual licenses in it were themselves Fran data points on a freestanding basis. And for this reason, which is right at the start of his thinking about it, they're not. In a nutshell, he regards the power of averaging here as indispensable for making a Frand assessment meaningful and to help him answer the Frand question based on the evidence he's received in this case. And my lord, as you've raised this with me, it might be convenient just to pick up on another of your questions to me from Friday too. You raised an exploratory question about whether a top-down royalty burden of 10% of the selling price of a normal phone, not an Apple iPhone, sounded about right.
Mm-hmm. Actually, it sounds a bit high, I must say, now I've thought.
Well,
there it is.
No, but that comment, it sounds about high, is actually important because we went back to look at the way things were in the Unwired Planet case, which is an older case and it had older information. And I perhaps don't need to turn it up, but in that case we saw there's a lot of the comparables that you were considering, the learned judge there was considering, were between 2008 and 2014, and the ones you said that you could place reliance on were from an earlier period.
Yeah.
And so it was an earlier period, it was on earlier evidence, and it was in that context that sort of figure seemed to come out.
Yes.
In this case...
Just to complete the thought for the benefit of everybody else, if I remember rightly, the figures, which I wasn't remembering, I was misremembering them actually when I asked you on Friday, that were quoted for the overall thing were somewhere around about 5 or 8%. Those were the numbers that were in the judgment.
Yes.
Which is yes, thank you.
So, returning to the evidence that was before the court in this case, a part of the argument, which hasn't been prominent in this appeal so far, was Apple's case that if you're going to use as a sort of royalty base a smartphone selling price, then you should take a basic level smartphone which strips out the whistles and bells and the other features that the Apple iPhone's got. And it was a higher end basic level smartphone that one could take. That had a wholesale price at the higher end of $125 on a wholesale basis. And Optis's expert confirmed that in his experience, these ad valorem rates are calculated on the wholesale price of the end user device. So in this case, that was the sort of evidence available, and that is why, picking up your Lordship's indication, we say that we have to be very careful not to apply intuition in this sphere, but to go by the evidence in the case. But your Lordship's absolutely right. If you are going to do so, those are the sorts of factors that one would also need to bear in mind as guardrails to be cautious. The distinguishing feature of this case, as compared, if I may say so, with Unwired Planet, is that you now have Apple before the court as a party, and Apple provides the court with a large spread of 18 Apple comparables, which cover about 50% of the stack. So this judge has the material to do averaging using a large amount of data, and that is why we say, just taking it point by point, that his approach of using those 18 licenses to get an average implied royalty burden for 100% of the stack was a reasonable approach given what he was faced with, and it was solidly grounded in the evidence before him. His first step, after he decided he was going to go through things in this way, was to lay out all the licenses he considered to be usable on an inclusive basis, and that was in Table 11, which starts at page 482 of the judgment. So we know that he is approaching this on the basis that any one of these individually isn't going to be a helpful comparable. I'm going to look at it all together to get my average. And that takes me now straight to the first of the implementation grounds of appeal, ground 5. That was the judge's decision to include 3 licenses with Apple, KPN, Orange and Tetri 2017, in his inclusive methodology. And then we will have after that, ground 6 of the appeal, the decision not to include the Qualcomm license, except in the particular way which we've seen. So to begin with ground 5, the argument by Optis, which is crystallised in paragraph 108 of their skeleton, is that the use by the judge of those 3 licenses was, number 1, inconsistent with the judge's decision to reject another Apple license, specifically it was Grand Mesa, on the footing that Apple was not relying on that one. And they say, well, if Apple says it's not relying on that one, Apple's equally not saying it's not relying on this one. And secondly, an error of principle. They say that neither side was relying on any of the 3. I've already, to some extent, foreshadowed my answer. The response is number 1.
Also, I mean, there's another point which I think is certainly implicit in Mr. Speck's missions, which is that if this is all geared upon the value of taking as much of the stack as you can, because if you take as much of the stack as you can, it's more representative, and you just explained that was the judge's approach,
Yeah.
then on that basis, you would include Grand Mesa, and you would also include Qualcomm, because that way you upped the percentage of the stack that you're considering.
My lord, at first sight, yes. And you're absolutely right. To go back to those paragraphs that I asked you to read a little while ago, the judge's approach is essentially a presumption in favour of inclusion unless there is a very good reason to exclude something. And what you will see he does in relation to both Grand Mesa on the one side and Qualcomm on the other is to say, I have a good reason. In short, for Grand Mesa, that was a case where, I'll give you the reference in a moment, the judge said, well, this particular license, the evidence says, has has absolutely there's no cellular SEPs in this. It doesn't cover cellular SEPs, so it's just not relevant for that reason. In relation to Qualcomm, your lordships already know the sort of reason that the judge adopted, and I'll come back to that. Now, my case on this, therefore, is that there's no inconsistency on the judge's part. The reference showing that he understood that Grand Mesa needed to go because it simply didn't cover 4G cellular SEP patents at all is on page 487.
Sorry, just before we get into the detail, can you help me on the basic picture?
Yes.
You say 4G. Why is 4G? What drives it?
Well, cellular SEP, I should say. We were talking here about a license for patents, which are essentially for a 4G enabled smartphone. So,
is that right? Is there no value for EG 3G in this?
no, those.
What about 5? Does the license not extend to 5G?
Well, 5G he then deals with at the end because he didn't hear argument about those.
Right.
And he says that, you know, I'm going to, if
Sorry,
your lordship
so
will patent
do I
his
take
basis.
it that the judge's license is 4G only?
It includes 3G. It includes 3G. Yeah. Yeah. Oh yeah. No. It includes. He looked at the 2G by this point very stale, but he looked at cellular SEP patents, including those which were declared essential to the 4G standard. The Grand Mesa case, just to
All right. So
complete the point.
what does the judge's license cover in terms of standards?
2G, 3G, 4G, and 5G.
Right.
Yes. So then, if you go please to page 487. Yes.
True.
Yes. I'm reminded that Optis's portfolio, this is a 4G patent portfolio, some of which may be redeclared to 5G specifically.
So you're telling me there's no 2G or 3G patents in it?
My recollection is that either there were not, or that they themselves said we don't claim any value in relation to such patents in this portfolio in their positive case. It was one of the two. Yeah. So the reference which we need not dwell on, but I'll show you, is on page 487 at 483 Roman 1A, and the reason why the judge knocks out Grand Mesa is because although Apple had suggested it wasn't a true comparable, he wasn't doing it on that basis. It was because he agreed with their reason, which was that it didn't cover 4G at all. And that was different from the other cases. And nor for the reason that I gave when starting my submissions on Thursday, was then error of principle on the judge's part, because it wasn't common ground that the Orange and KPN licenses certainly were irrelevant. I showed you that Optis's expert explicitly did rely on those, and even the third of the licenses, ETRI 2017, was covered in his report, and I gave you a hand up on that. And this was in circumstances where the party, Optis, said in its skeleton for the trial that it was going to rely on the totality of the licenses considered by the expert. Yes, I'm grateful. Yeah, my recollection was correct on that. There was no claim made by Optis for any value in respect of 2G and 3G patents. The reference is paragraph 16 of their position statement, which for your note is Core Bundle 3, Tab 2, page 28. So, my lord, that's all I'm going to say about the first of these implementation grounds. The second is ground 6, the complaint about the way in which the judge chose to deal with the Apple Qualcomm license in his assessment. And I've already dealt with Optis's arguments that the judge was wrong to regard the Qualcomm license as a suprafrand license, and that he erred in law by not using it as a freestanding comparable to Optis in its own right. The remaining points that are made by Optis, which are ground 6, are these. First, the judge's way of accounting for the Qualcomm license in his methodology had, and I quote, no proper mathematical foundation. Second, that what the judge did denuded the Qualcomm license of any corrective effect. So that's paragraph 113 of their skeleton. And we can test both those points. And I say that you have to begin by stepping back to bear in mind the purpose for which the judge was including this figure for Qualcomm, his adjusted figure, in the first place. And if you have the main judgment open, please go to page 491. And on that page, it's subparagraphs B and C, which are both significant. This is what I have already, to some extent, addressed the court on. And I repeat the point that I was making on Thursday, that the judge was not actually looking to reflect the Qualcomm license in itself at all. He was looking for something else. He was looking for a way, as he says, to allow what he calls in B a helpful corrective to be introduced to cases where Apple may, found no evidence of it, but may have exerted its own market pressure on smaller counterparties. It's the first few lines of letter B. He took a number that had a significant effect in bumping up the average price for the whole stack. And that was in an amount that I mistakenly uttered on Thursday afternoon, which I won't go back to. The judge, given that that was his project, he didn't need a strict mathematical approach for what he did. And the method that he chose, which was to dilute the impact of the Qualcomm license itself. If you go back to page 490 and look at letter Roman 6 at the bottom of that page, you see what was going on there. He was diluting it because it accounted on its own that amount of money for a very substantial part of the total royalties paid by Apple to all the licensors. And that's why he proceeded in the way he did. We say that given what he was seeking to do, two things follow. The first is my response to my Lord Justice Arnold. On inspection, he is not truly including the Qualcomm license at all. What he's doing, in substance, is including, as he says, a helpful corrective to the point that he deals with on the following page. We can see that. The second point is that he could have approached doing that in any number of other ways. He could, for example, have said, I'm going to bump this number up by X% to be on the safe side, in my judgment, as an evaluative matter. It was ultimately a simple exercise of evaluative judgment, and that was the way that he presented it. So that is what he did, and that is what we say about it. Now, the next ground is ground 7. This is the alleged failure to weight licenses according to stack share when the judge was implying aggregate royalty burdens from them. And the court's aware that what he does is he takes each one by itself and he says for each one, what is the implied average aggregate royalty burden? And then at the end, he applied a simple average to get his figure after having knocked out the outliers when he stood back and looked at the figures. This is described as an error of principle and contrary to the common ground between the parties. Our submission is that it's neither of those. First, it's not an error of principle because there's no compelling reason why an agreement struck with a licensor, which has, say, a 4% stack share, should necessarily be more informative of the value of the total stack than an agreement with a counterparty which has got a smaller but still significant stack share, say 1 or 2%. In each case, the negotiating parties can be expected to have had the aggregate royalty burden in mind, at least as a talking point, in line with the Commission's guidance and an approach to FRAND in this field. And although Mr. Speck referred to an extreme case where one would say if someone has 90% of the stack as a licensor, someone else has 10%, which one are you going to give more value to? One sees that as a reasonable approach entirely. But here, where one is talking about a cluster of very fragmented market shares of a far smaller degree, take the range 1 to 5% or so, our case is that there was no obvious logical error why the judge should not have proceeded by treating each one as valuable, equally valuable in its own right in the way that the judge did. The second point is that it was also not common ground between the parties that when you're considering comparables, you take into account, well, is this one more important than another because it represents a higher fraction of the overall stack in terms of the share of the particular licensor. Neither of the parties' accounting experts undertook weighting of comparables according to licensor stack share in the case. In particular, Miss Guttridge for Apple, she simply identified a group of 14 or 15 Apple comparables that she considered were useful to the FRAND question, and she concluded neutrally by saying here is a range in which a FRAND assessment may fall, having a look at this group of comparables. But she did not rank them by the stack share of the licensor, nor did her opposite number Mr. Bizant. And I've shown you in the references I gave last week, and go back to those if the court wishes, that the parties didn't do so either in their primary comparables cases. Perhaps I'll just remind you of the Apple position. So if you pick up the Apple position statement, that was in Core 3 at pages 61 to 62. So you see under a table in which, in blue, a group of the comparables relied on were all set out, and you see their shares of the stack in column C. The approach that was taken is described in paragraphs 45 and 46. And at 46, as I mentioned on Friday, the expert refers to a subset of the comparables that were particularly useful and worked on that basis to arrive at an answer. But what is not done is a ranking by stack share of licensor nor was that a feature of the opposing expert's approach either.
Well, it may not be ranked, but as we see from 45, it's said to be on the basis of scaling by reference to the proportion of declared essential patterns for the relevant standard.
I'm sorry, my lord, where you...
That's the first sentence of paragraph 45.
Yes, my lord, that's right. That's there is scaling there, and that was in order to get down to an implied rate for the PO portfolio. But in terms of the importance that is attributed when determining what rate is the right rate to adopt as FRAND, the expert doesn't say one accords greater importance to the ones which have the higher stack share. That's the only point that I'm seeking to make about this. Now, in their skeleton argument, it was not pressed hard in oral submissions, I believe. Optis says, well, Miss Guttridge did use weighting in other contexts in her report, so there you have it. That is not a relevant point. I can explain it in a moment. Miss Guttridge had another approach to valuing, apart from comparables, which I mentioned last week, and my Lord Justice Arnold referred to some familiarity with it in a different context, which is a sort of profits available approach, an economic benefit approach, she called it, where you seek to work out the profit available from either a basic level handset or, in this case, a chipset, which is where the cellular technology was located, and then see what's available from it to be paid to the set licensors. And what she did when she was looking at that part of her methodology was to estimate the average price of a Qualcomm chipset, which looking at the chipsets, by getting a weighted average from the selling prices according to the number of units that were sold of those chipsets. That was the sort of context in which she was using weighting. And my submission is the fact that one of the approaches put forward by the parties involved doing that is neither here nor there and doesn't take things further. The question for this court is whether there is, stand back, an appealable error, because when the judge was considering this averaging, as he does, he did not proceed to rank these different licensors by stack share. My argument on that is, no, what he did was a reasonable approach. You could have done it by ranking according to stack share, and one would have said that that too is a reasonable approach. But this made sense and shouldn't be criticised on that account.
You can see, can't you, from the table that you just showed us, well, it's just above the text you were showing us in the position statement,
Yes.
that the relative, just by seeing the implied rate for Panoptis and then looking at the stack shares, you can see that there is quite a difference in, if you imagine a sort of what is 1%, or it doesn't matter what it is 1%, a given percent of the stack share worth.
Yeah.
That's very variable in this collection of data. You can see that from the implied Optis rates.
Yes, there were these differences, and my lord,
It's a wide
that's
variety.
well, absolutely, that's right. And one asks, well, what does one gather from that? In a sense, it does support the judge's approach that you have to exercise caution with all these comparables because there are other things feeding into the license that is granted, and him deciding, therefore, that the right approach is to use an inclusive approach to come out with something that approximates to a FRAND figure at the end of the day, partly because of those wrinkles.
Okay.
And one can't say, by the way, either that one always sees the larger parties with the larger stack shares getting the better rates. Just on this table, if you go down 1, 2, 3, 4 to the fifth entry, for example, you have a party there with a relatively high share of the stack, and you'll see the implied rate is a lower amount in the right-hand column. Yes, that's right. So, my lord, I'm not going to say anything further on that. That is ground 7. And now we come to two of the more important grounds, where, in my submission, there is more meat to be considered than in grounds 5 or 6 or 7. So these need to be looked at more carefully. The first is ground 8. And if you turn up Optis's skeleton on page 86, go in it to paragraph 117, top left. So the ground is described as a failure to normalise for sales volumes. And the ground, as it's set out, it has 3 parts. It is concerned with the failure to account for differences in the expected levels of sales in Apple licenses. The Optis says, well, the judge should have done that. It draws attention to the fact that with cross licenses, what the judge did was to effectively assume that the cross licensee, the set owner, is selling the same amount of devices as Apple does. And you'll see from paragraph 120A, get the reference, but essentially they say that can't be, there we are, a C. Cross license is C, 120C on page 87. You see that that's a mistake, because they make the point that in the case of every Apple license, you've got somebody who's selling, where there's a device sales by that SEP owner, a smaller number than Apple. And that should have been taken into account. But what the judge does when he's trying to work out the impact of cross licenses is he asks himself, what is the gross stack share of a set licensor? And then simply deducts from that a constant figure representing Apple's stack share in every case. So they say, well, that's got to be a flaw. And their third point is in relation to the Google license, where they make the observation, and I'll come to that, but we don't resist it in principle, that he treats the Google license in his figures as though the lump sum is given in relation to a license for what is an expected volume of sales by that licensee, Google, in Optis' case, which is equivalent broadly to Apple, whereas we know that it's a far lower amount. And so their point is, well, in that case, one should definitely scale that up to account for the radical difference between the small level of supplies, of volume of sales expected from Google on the one hand and Apple on the other. And they say that if you do that, that strongly affects the figures. So those are the 3 parts to this ground. And although Mr. Speck said that he is approaching it as a single complaint with 3 aspects, we say that it is perfectly possible and right to look at each of these points separately. They do not stand or fall together. It's perfectly sensible to consider whether in some cases not accounting for the volumes and making a simplifying assumption works, and not in other of these situations. So if we begin with the first part of this, the Apple sales volumes, The first argument here is that the volumes of devices covered under each of the patent licenses to Apple will have varied, and the judge oughtn't to have assumed that the volumes sold by Apple would all be roughly of a similar magnitude. He should have normalised them. He should have ensured that any differences between the expected sales volumes covered by the Apple licenses and a norm were recognised. And our responses are twofold. First, the complaint that the judge's simplifying assumption in relation to the Apple licenses was an error of law isn't well made. Second, if the Apple licenses had been normalised, it wouldn't have led to a higher number for Optis at all. So beginning with the first response, the judge's implicit simplifying assumption was that under these licenses to Apple, the expected volumes of device sales by Apple were sufficiently similar not to require adjustments. Now, it's true he does not say that in terms, but he confirms it as much if you go to the consequential judgment and turn in that to page 54. You'll see on page 54, Optis sought to appeal to the judge against his ruling on a certain number of grounds. Those multiplied the purpose of the appeal to this court. But in Roman 2, 1012 on that page, the judge deals with this point that he'd failed to take account of sales volumes. And it's interesting to see his response. So from the third line down in Roman 2, he says, these grounds fundamentally misunderstand the court's methodology, which was to calculate a lump sum rate that was found in relation to Apple. Inevitably, all the Apple comparables, then he adds in brackets, which apart from the Google 220 Optis license were the comparables used by the court, would have taken into account Apple's sales volumes and ASP. These values would have been baked in and didn't require separate consideration. So there's something of a wrinkle there, because even in his answer he's saying, you know, I recognise I put Google in there too, but his essential point is that the logic of what I've done is that I'm baking in an approach because I'm treating all these Apple licenses as much of a muchness in terms of the expected sales volumes.
Would it be fair
That's
to
not
say-
what he says. He says the opposite. He says it's inherent. So his reason is even if the sales volumes are quite different, it's inherent in the figure he's used.
Well, my lord, I accept that when he uses the word baked in, that is one way of reading it. Our submission is that in order to understand it properly, one needs to bear in mind that it must mean that he is talking about similar volumes. And his assumption seems to be that when you're dealing with the Apple licenses, he didn't need to go into this level of detail. It's a complication he didn't need to address because the question of volumes is taken care of by looking at a stock of Apple licenses in particular. That's how it must be understood. And it accorded on that basis with the evidence that was before the court, which was that the Apple sales volumes of devices, which is very largely the iPhones, launched in 2007, had become mature and they were broadly stable within a range, at least over the period of interest in this case, 2014 to 2022, with some ups and downs. And my lords, you're aware that insofar as this was not an explicit part of the judge's reasoning below, this is a point which is a respondent's notice point that we have raised. It's paragraph 4 of our respondent's notice. So we say that there were therefore alternative or different grounds by which the judge could have reached his conclusion on this point. And if you would please take up again, I don't know if you have it to hand, the A3 hand up that we circulated when Mr. Speck was drawing your attention to this, somewhere in your papers. No.
Can you remind me where it was, just sort of numbering?
So I put this in.
It simply replicates a smaller version.
It replicates
So
the
the
smaller
numbering
version.
stays the
My
same.
concern was that the smaller version.
No, I follow that. It's just in terms of where to find it, because I put
Well,
it with the smaller version.
I apologise in that case. I don't recall where it was filed.
It's up to 40 and 41.
No, but is that the electronic version?
No, I think it's
Mr. Sepsu says that the smaller version is
Yes.
supplemental bundle 2 at either tabs 40 or 41. 40, thank you.
That does indeed produce the A3 version.
Oh, it does?
Yes, in my file.
Now, I'm looking at the same information that Mr. Speck took you to, but in the column headed estimated annual volume of cellular units sold, which has got a reference to an appendix from Miss Guttridge's report apart from this one, a later appendix. If you run your eye down, you see the licenses are here arranged in chronological order with Huawei at the top. And I'm not sure if this is confidential, so I won't go into any detail, but you see what's at the bottom, and that's December 2020. It's a 5-year license at the bottom. If you run your eye down the page, what you see is on a fairly cursory visual inspection that you don't have significant fluctuations from license to license.
Depends what your definition of significant is. I mean, on some people's view, the difference between 1 and 2 might be regarded as significant.
No, my lord, I take that. The submission is that it is not, in this context, a significant difference. We'll look in a moment at what the normalisation factors actually mean. By and large, you're looking at a 10% swing.
Also, Mr. Turner, since this is a lump sum, surely you should look at the next column, the estimated total units sold over the lump sum, not just the total units. That's you're looking at the annual sales, but what Ms. Guttridge, presumably this is Ms. Guttridge, then did, was estimated the total number of units that the license, which is a lump sum license, was relating to, and you can see the difference in the first 2 rows then is even larger.
Well, my lord, yes and no. Of course, that's very important. But if you're seeking to ask yourself whether licenses, if you assume these are for different license terms, you see. Exactly. So the differences that you see in the column that you were looking at is sometimes explained by the differences in the license terms, which leads to, obviously, to the much greater numbers. But if you're asking yourself the question that the judge is interested in, which is the annual figure, so that he can get an annual average price for the entire stack, it does make sense in my submission to focus on that.
Well, only if you're assuming, as I think you're saying the judge was assuming, that these licenses all have the same term, but they don't.
Well, this is where what he's seeking to do is to work out an annual average price for the stack is his goal, and in that connection to look at the annual average expected sales of Apple is the most informative metric.
Did he divide the lump sum by the number of years in the term?
Yeah,
Okay, I don't think
yes, he does, and we'll come to that shortly.
If I knew that, I'd forgotten that. I'm sorry.
But the point here is that what he is doing is looking at the stock of licenses where, by and large, you have a similar magnitude, at least for his purposes and the way that he's approaching it.
I mean, just picking up my Lord's point, between 1 and 2, going by the column you've drawn our attention to, it's still a difference of high 20s% or something.
You mean the first and the second rows?
Yes.
Yes, I agree. That first one is the outlier. The sales become mature over a period. That first one is the difficult one. I accept. The others fall within a fairly consistent range, which is explained by the maturity of the sales profile at this point in the life of the major product. So the submission is that what the judge did, and we can all see that he simplified it because he didn't take this into account, did not amount to an appealable error of law because there was no inconsistency. It was not an illogical approach, at least if he had approached it by saying, I will simplify by assuming that these are all on the basis of a roughly similar sales volume. It is a simplifying assumption. And that brings us to the second response, which casts light on the first two, and it's whether the normalisation for which Optis is contending in this case, and says that the judge failed as an appealable error to carry out, would it have made a material difference? Is this a point that significantly affects the outcome? And for that, I'd ask the court please to turn up supplemental volume 2, go in it to tab 16, on page 56. Now, you've seen this, I think, before. It's the letter from Apple solicitors, which was sent alongside our skeleton, responding to Optis's original spreadsheet, which was sent alongside their appeal skeleton. If you go in it to page 60, and you have to turn that on its side if you've got the hard copy, you've got table C. And this shows the effect of normalising. So in the middle of this, you'll see a column, Miss Guttridge's estimated annual future sales volumes, and a reference across to the appendix that we were just looking at.
And these are rounded figures for some reason.
The number of millions, yes, it's not with decimal points. But it's in order to give you a clearer picture of the broad magnitude of the sales volumes on an average annual basis. On the right-hand side, you have the sales volume normalisation factor. So you take what is the average normalised volume at value of 1, and you look at the difference represented by each of these as a departure from that figure. And you will see that again, apart from in relation to the very earliest license, which does stand out, and that's, to answer my Lord Justice Newey's point, that's now at row 11, because these aren't in chronological order. What you have here is figures that are within 0.1 or 10% of the average. And if you go...
The average is... where do I see
So you won't see any one of these as the perfect average.
Yes.
But what they've done is they've added up all these expected volumes.
So the average would be somewhere between the Longhorn figure, well, the row 15 figure and the row 11 figure, would it? If you're saying they're all within, well,
Yes, I mean you can see what figure it actually is in absolute terms. You look at the bottom row and look at the average under Miss Guttridge's estimated annual future sales volumes. So all of those have been totted up and then averaged, and that's the bottom figure. Can I read that figure out?
Yeah.
Right, so that's the 223 million at the bottom there, and then all of them are compared against that.
So just to understand, I'm sure it doesn't matter. You say they're all within 10% of an average, which presumably means a mean rather than any other kind of average.
Yes.
And just looking at the sales volume normalization factor, you get a span of 0.24, do you? 0.26, 0.24.
No, it's 0.28 because it ranges from 0.9 to 1.18.
Oh, I missed a 0.9. Oh, yes.
Oh, because for the 1.80.
0.28.
Yes, the 1.18. Yeah, that's right.
That makes sense given the 1 and 2 rows in the previous one. But you're still, each of those is within 10% of the average.
Apart from that one that, my lord, you rightly picked out, which I'm not going to say anything further about. That's in row 11.
I see. So you take up row 11. So otherwise, the highest would be row 6 with it.
See, yes, that's right. That's right.
Yes, I see.
So what this does is then, having produced the normalization factor, it then sees what the outcome is of adjusting this and applying the normalization factor, which is a fairly simple way. Assume that the judge has made an error. This is the simplest way of approaching the correction of the error.
Yes.
And you end up with an average figure, which I can't read out, thank you, which is at the bottom right. And that mystery number at the bottom right is actually a few percentage points smaller than the figure for the total stack value, which we can read, which is 2.7 billion, which the judge's simplified approach came to. So one sees two things. First, that it's a few percentage points below, not much. And secondly, that it is in fact below, which, when one's considering that this is a point of appeal for Optis, is significant. So our case is that you can treat that in itself as a point to consider. You don't just have to say it's either treat sales volumes as something that must be taken into account across the board in every context or not. It's not binary in that way. And if you look at this particular aspect of it, those are the arguments as to why this is not an appealable error.
Yeah.
The second aspect of this is the cross-licensing and the proposition that the judge ought to have taken into account that the cross-licenses by Apple to the set holders would have covered sales volumes of 4G devices by those parties which were different from Apple's sales volumes of the iPhone and the like, and they were universally lower. And Optis rightly does observe in its appeal grounds, we do not argue with it, that the judge's approach was to treat the cross-licensee's annual sales volumes as being equal to Apple's in every case. Our point on this is not to focus only on the magnitudes, but to point out that this broad brush approach on this point by the judge, if you think about it for a moment, is unambiguously generous to the appellant, to Optis. And the reason for that is that because the judge is taking the stack share of the licensor and knocking off, in every case, a constant figure, which is the Apple license, going the other way to them to get a net figure. If you're saying I don't need to account for the volumes being sold by the licensor, if you are thinking to yourself, therefore, that the value to that set licensor of getting the license from Apple is higher because you're pretending that that set licensor is selling as many devices as Apple does to attract royalties, the result is that the net stack shares are smaller under this approach of the judge than they would have been if the judge had done a more precise job. And that has the implication in turn that when the judge goes on to scale up the individual lump sums which are paid under each of the agreement, as he does, to try to reflect a price for 100% of the stack, and he does that using as his method the net stack shares that he has arrived at, what he does is to magnify, where there are cross licenses, the amounts of money in each case. It follows, and now I'm talking about the impact so far as the logic, that under the judge's approach, the estimates of what 100% of the stack price to Apple should be in the judge's methodology are generous to Optis because he creates a larger pie to give Optis a slice of. Now,
Can I just understand that? I'm sure you're right, because just so I understand.
no,
So, take some imaginary cross license, where assume the ultimate lump sum is, I don't know, 10 million. And that's on the assumption that the license granted by Apple relates to a larger number of units than is the reality.
yes.
So just talk me through how the rest of it follows.
So, because of that, were it not for that, if it had been properly recognised that the amount of units on which the licensor needed a license from Apple was a lot smaller, perhaps extremely small, then the value of the cross license would have been, in commercial terms, should have been lower.
Yes, I see.
But because it's made higher by this wrinkle, what it means is that the net stack share, which you then use in order to gross up to find an aggregate figure, is going to be too generous. Now, in every single case, if we open the judgment, my lord, try and find the reference for this, where there's a cross license, this is what he does. It leads to, therefore, those figures being higher than they should be, which is advantageous to Optis in this case. And in one particular case, I can mention this, but I won't go into the numbers. I can mention it. I can mention the identity. I'm going to try to do this anyway. If you go to page 486, I won't mention
In the judgment.
in the judgment. Go to page 486 in the judgment. You have in the second box down a company, well-known household name, but one that we saw before in connection with the witness, Mr. Rockhour.
Yes.
And what you'll see there is that the figures that the judge treats of interest for his methodology are set out. And if you look at the percentage of the stat there that licensor had, which is not in blue, and you compare it with the letter E, what's the cross-license stack percentage of Apple? What the judge has done is he's just made a straight deduction. He hasn't taken into account this volumetry at all. The result is you've got a net stack share, which is extremely small. You see that? What? Yeah. Yes.
Yep.
Yes. Sorry, I'm reminded this is on an annualised basis, as you can see. So there's the net stack share, which is incredibly small. And if you then use that as the stack share from which you are going to derive, well, what's the implied average share for the whole thing, for 100% of the stack, and you multiply that up, you get an absolutely enormous number. And that's what happened in that particular case.
Yes.
And that led, for that licensor then, the judge to apply some different approach, don't need to go into for this appeal, to actually to strike it out.
Yes.
When he doesn't strike it out, he changes it. So if you go to figure, or table 13 on page 489, what you see there, bottom of the page in the figure, the first row is that company. And you can see from the blue what the implication of what the judge has done with his cross-license method is for that company. You get an absolutely enormous figure. And using various other adjustments, he says, well, that can't be right. That can't be right. And he strikes it out and he substitutes a different figure, which is still, by the way, high figure compared to all the others in column 4, average 3.
Yes.
So the point is really first to explain to your lordships what he has done, and secondly to show you that the implication of what he has done on this issue is something that is unambiguously generous to the licensor. Now, we pointed this out in our skeleton argument. Actually, I think we first pointed this out before the skeleton argument, potentially in the PD 52C objections. But what Optis then does in response, in its skeleton, if you go in their skeleton to page 87, paragraph 120D, which is at the bottom right-hand side of the page, what they do is say, no, we've got this wrong. As you see, it says, D, as to Apple's claim that the judge's approach to cross-licenses was generous, they say if the judge's method is corrected to take into account sales volumes, you get to a figure of £154 million, which is a lot higher than the judge's figure, which was about 56 million for the same. So they say, so we must be wrong. That was, as we sought to point out in our skeleton argument, it's paragraph 132, essentially a sleight of hand. It's connected to the way that Mr. Speck presented the point to you as saying all of these volume points must stand or fall together. And the reason is that they get to that figure of $154 million by wrapping up together all the various adjustments that Optis says should be made under Ground 8, including the one that I'm about to come to, which is the colossal effect of using the little Google 2020 license in his methodology, where the judge had forgotten about the difference between its expected sales volumes and those of all the Apple licenses generally. And it's pertinent to look straight away at the effect of doing that on the the Frand assessment. Perhaps the most convenient place for that is if you go, please, in sub-volume 2, oops, to the letter from our solicitors with calculations by Deloitte. That's at tab 16. And you go in, it's page... Where's it? Yeah. So if you go in, it's page 57, look at table A. Table A, if you look at the top of page 58, these are the calculations underlying the figure that they were saying is the right figure at that point in time for their skeleton argument of $154 million. So if you see that at the top of page 58, where the table has spilled over onto that page from page 57. And that figure of 154 million, which they've got there then, is not the result of just correcting for the cross licenses. What it is the totality of their substituted methodology, which you've now seen in outline from the submissions made by Mr. Speck and myself respectively, where what they do is say, well, we're not going to use this normalization of sales volumes in the way that that I outlined, which is perhaps the simplest way. We're going to go back to the basic method of unpacking individual comparables, using the experts' figures for each of those unpackings for each license. And here this is Mr. Bizant, which is what they were relying on. And doing the exercise entirely on a license by license basis. And you will see in the way that they do it, that if you look at the left-hand column, which is DPU, dollars per unit, scaled to 0.38% of the stack. So they're working off the enography figure for the share of the stack that Optis has. And if you run your eye down it, you'll be reminded again that the Qualcomm figure in row 2 stands out above all the others, apart from one, which is the Google figure in row 17, again, and you see the relationship of those two. And then if you move over to the middle column, and you're looking now at free release unpacking, where you're not allowing, therefore, anything for the past in your unpacking at all, you get an even starker picture where the Qualcomm figure you see in row 2, it's the same, for a reason that I'll come to, because it was treated essentially as a running rate for each period. And then the Google figure, which I won't read out, which we read before on Thursday and Friday, is not just head and shoulders above the others, but absolutely dwarfs all the others in the table. That then leads to, when you tot it all up, the total, which you see in the penultimate row at the bottom, and the high average figure. So that the effect on the averaging of including Qualcomm on the one hand and certainly Google on the other, it produces an absolutely enormous effect. And while we're in here, just to get a sense, because we're coming on to this now, and you've got this open, if you go forward to page 63, there's the table which compares, and we'll be coming to this in a moment, the sales volumes relating to Google on the one hand and Apple on the other, looked at according to two different estimates of what the Google sales volumes were going to be. Those are in column C. And you see in the final column that based on substituting for the figure that the judge had in column A, we'll come to this in a moment, for his inputting of what Google means for an implied aggregate royalty burden per year. This is not confidential, is it? Those are confidential. The three-digit figure there in column A, you compare that with the adjusted stack figures in the final column, E, if you multiply up by the sales volumes, and you can immediately see what impact that would have produced if the judge had thought to himself, I've got this wrong, I've got to include a figure for the for Google, which allows for the disparity in the volumes. He would have seen that that figure would need to have been included rather than the figure he used. And it's, I'm sure I can say, the implied value of the whole stack to Apple becomes a number in the high tens of billions. So that then takes me to this third point. The third aspect is Optis's claim that the judge erred, and it's appealable, by failing to take account of Google's much lower sales than Apple's when he was choosing to use the Google license in his methodology alongside all the Apple licenses. I mean, in a sense, it was, and neither side is disagreeing on this, it was a cuckoo in the nest. The judge, we don't shrink from the proposition that the judge should, if he thought about it, if he was going down this path, have increased that. Why did he include it? It was because of his wish to be as inclusive as possible, but we do not resist the point that he slipped up in doing that. This then connects with a point in our respondents' notice, because we say it would have been right for him to have confined himself to the Apple licenses, which would have fitted with the logic of his approach explained in the judgment. And I take my Lord Justice Arnold's point about the use of the phrase baked in that we saw in the consequential judgment. And if I may, in that regard, I'll simply remind the court of the following passages from the main judgment, which show you that this is in line with the logic of his approach. In the main judgment, you have paragraph 456 on page 466. That's where, under the heading articulation of an approach, under methodology, he says the best approach, it seemed to him, to resolving this articulation of the Frown question is to seek to price the value of the entire stack to Apple. And then he goes on, if you go to page 470, we saw this on Friday. He says at paragraph 464 at the top of the page, he actually says a lump sum must be calculated by reference to the implementer seeking to license the portfolio in question. Now, on one view, there's the point my Lord Justice Arnold raised, which is that's abstracting from the sales volume issue. On another, it's simply making the assumption that that particular party will be selling an expected annual level of devices at the same rate constantly, and so he doesn't need to take it into account. Then below that you had the two footnotes that I took you to on Friday, which are very clear. Footnote 598, calculation of the lump sum price must therefore be specific to Apple, and the Apple comparables are therefore of the most significance to this part of the exercise. And also, finally, if you go to page 492, because this is a constant theme of his judgment, paragraph 487 at the bottom, he's quite clear. If you look 3 or 4 lines up from the bottom, he says, the rate I am computing is specific to Apple. I have used the Apple comparables for precisely this reason. And then he says, if an implementer had materially fewer sales or sales at the lower SP, the price for the portfolio would be lower. That's an insight which is correct and one which he does not implement in his reasoning. Now, our case is that excluding Google would have been the right thing to do in his methodology, and doing that would have been consistent with the considerable concerns that the judge himself expressed.
Just remind me, why does an implementer with lower sales, for that reason only, have to pay
A lower
price?
Well, the idea, my lord, as I understand it, is the very simple point, nothing more, that if you're licensing a party such as Apple, deciding the lump sum that they're going to have to pay, and you have in mind a per unit rate, which would be a fair rate, that you take into account that it's going to relate to a very large number of sales units over the license term. Whereas if you have a party which is only selling, well, if you take Google itself in this case, a very small number of assumed units each year, then that would gross up into a lump sum that was necessarily a much smaller amount.
Yeah, so it's all driven by the fact that this is a lump sum.
Yes, it is. Yes. But it's driven by the fact it's a lump sum, and it's driven by the fact that what the judge says is, what I'm seeking to do by staying at the lump sum level is avoid a difficulty which he's detected occurs if you have to unpack it using assumptions to get to a per unit rate, and then ultimately at the end of the day repack it up. So he considers that this is a way of avoiding those difficulties, and that's why he's approached it in that fashion. Now, the judge was aware, I mean, you can see here that he's forgotten at that point the impact of the Google license for this purpose. That is clear. But we say that he nonetheless recognised, when he was thinking about this in terms of an individual comparable, and to go back to that point, he was not thinking that individual comparables were going to be the way to go in terms of getting a Fran number at the end of the day in this case. But when he was considering Google itself, there he did stress test it. And if you go to page 476, just to remind you what he does, on the right-hand side, Roman 3, at A and B, onto Roman 3, he takes from the previous pages the opposing expert, Mr. Bizant's figures for the unpacked rates for this license. And I pause there just to make a point which won't have evaded your lordships, which is that we had been talking up till now as though the expert simply the judge put all the experts' work into the bin. And your lordships know, perhaps it's too obvious to state, but he doesn't actually do that. In his own methodology as he goes along, he is having an eye on what these unpacked rates are, and in different parts of what he does, it is fair to say that the judge is using the experts' methodologies. So I don't want the court to take it that he somehow put it entirely out of his mind. And what he does is he takes Mr. Bizant's unpacked rates for Google, which are back on, I think, page 471, about 8 lines up, 8 or 9 lines up from the bottom of that table, they're in blue, on what he called the free release basis and a simple release basis. And you'll see that in that license, the stack share was 0.61 on the right-hand side. And he took that and he multiplied it up to get from 0.61 to 1%, from which you can very easily get what the whole stack costs. And then he produces his own figures, having done that simple arithmetic, on page 473, where you see the Google number about 10 rows down from the top. So you'll see there's the numbers when he's changed 0.61% into 1%. And then if you go back to 476, those are the numbers that he is referring to in Roman 3 letter A, where he talks about the rates that Google were charged, what they are in ad valorem terms. And he unpacks those. He explores the implications of unpacking those in B, and you'll see in particular the last sentence of B, indeed paying that large fraction of the selling price of the phone, that is, for a license to 100% of the SEPs comprising the stack, that's indefensibly high, because it only leaves the remainder over for all other costs and profit. So at that point, the judge has said, if I look at this individually, I do see that there's a problem here. What he had not done is realise the read across to the exercise he does carry out, where he doesn't adjust for sales volumes and puts it in at a number which is too low. Now, if we're right, if the court accepts our case on this about how the judge could have gone about it, if he had used only the 18 Apple licenses as the material for his approach, if he had excluded the Google license in the way that he used it, the impact on the FRAND royalty payment due from Apple, determined by the judge, that would have been very small. So if he had not used Google at all, how would things have looked compared to where he ended up? That's shown in the Deloitte's table. If you go back to supplemental volume 2 again, and go in it to tab 16, page 62. I'm not going to read this. Okay, I'm not going to read this. There you've got the table D. It's headed excluding Google 2020 from table 13 of the judgment. And this is again a simple mathematical point. What they do is for row 17, which is now in grey, they just remove that, say, well, what happened if the judge had just said, well, I'm not going to include that because that's inconsistent with the logic of my thinking elsewhere. And it shows that, I mean, partly because he didn't take it, well, entirely because he didn't take into account the implications of scaling it up. If you knock it out, the figure you get in the bottom box, which is expressed as a lump sum in the second row, is that confidential? Yes. Is not very different from the figure of 5.13 million, which was the judge's figure, which you find in paragraph 494 of the judgment.
So I'm really not trying to put this in a tendentious way, but can I just make sure I've understood what you're saying? What you're saying is, because the judge made a mistake in the way he actually took Google into account,
Yes.
didn't make as much difference as one might think it should have done if he hadn't made the mistake.
Yeah.
And therefore, because it does, if you don't make the mistake, it does make a big difference, and therefore you shouldn't take it into account.
Yes, well, that's actually the point that I'm literally just about to make.
Sorry.
No.
Anticipate your
No. So really, we approach it in two ways, but it leads to the same outcome. The first point is, if he'd followed his own logic, he wouldn't have had Google in there at all.
Right.
He would have seen from the what we've just looked at in relation to the implications of it on a standalone basis that there's a problem here. And he would have said, well, it reinforces me in my determination to follow the strict logic of my approach, which is I've got the stock of Apple licenses with all of the reasoning about how that then abstracts from the difficulty which would otherwise arise as to sales volumes, and that's the way I should have gone. Our point there is, had he done it in that straightforward way, and this point would not have arisen, you would have ended up in a very similar place. Yeah. The other way of looking at it, which gets you to the same point, is a thought experiment. Well, had he scaled it up and produced the cuckoo in the nest, so that he would have looked at all of these little chicks and then this very large chick in there too, he would have done what he did with
the other cuckoo.
The other cuckoos. Well, yeah. He would have chucked it out at that point. And you see that from the way he proceeded. and that therefore, either way you look at it, you would have ended up at that number. Our point is that this is not a reason in itself, therefore, to say you have to tear up the judge's methodology. It is correctly an observation that the judge has made an error in the implementation of it, and those are our submissions about it and how it should be addressed.
And forgive me for one last question. And again, I'm not trying to put words into your mouth. I haven't quite remembered whether you are submitting that the judge's judgment was right for the reasons he gave in relation to this point.
No, we're not. So in the
I kind of didn't think you were, but I didn't want to say
no.
That's all
I
right.
think it's paragraph 7A of our respondents' notes. But basically, we can
That's
see.
all right. That's all right.
No. I'm just saying we can see that there's a problem there. We say that that's because he did something which wasn't in line with his own approach.
Understand.
So we then get to ground 9, which is the complaint that the judge went wrong, appealably, because having used the lump sum agreements to come up with an average price per year to Apple for the whole stack, which is the 2.7 billion, which he's got from averaging all those other numbers and bumping it up a bit to be favourable to the licensor. He says to himself, that treated the past as entirely royalty free because I'm only looking at the forward-looking license terms in each case and dividing by that number to get an annual figure in each case. And he says, well, I have to make a deduction for past sales payment, past release, and he deducted 50%. He cut it in half. So in other words, he works on the basis that he could assume a 50-50 split between payment for the past and payment for the future in the Apple licenses that he's working with to derive a FRAND royalty. The case made on appeal is he didn't have a proper evidential basis for doing that, and as you heard from Mr. Speck, that he was really going by what he thought should be the case, that you shouldn't discount for the past, and that you broadly have an equal period for the past to take account of as in future term in these cases, rather than what he saw before him was the actual evidence about these comparables, which should have been the right consideration for him to address. Our response is that it's correct to say that you should focus on what the evidence was in relation to these comparables, the 18 Apple comparables. That's certainly true. But we say that the judge did do that, and he did have a proper evidential foundation. Some of this is again supported by a respondent's notice. And the starting point is the key parts of the judgment, which are on page 492. Paragraphs 484 and 485. It's a very short part of the judgment. Heading is value on a free release basis, and you'll see at 484 he records he has valued 100% of the stack for a year's license to Apple at 2.7 billion. He sees that it ignores any part of the value that's attributable to past release. So the question he is now grappling with here is, well, to what extent do I discount that sum? And he deals with it in 485, which is where the argument focuses. At 485, he notes that it's not possible to undertake reliable comparable by comparable unpacking of the lump sums. And that is because he has considered throughout the judgment that there are too many uncertainties to be able to do that sensibly in any given case. The court is by now familiar with that. He feels that there's a lot of things that need to be looked into. He didn't feel that the individual experts, when they were unpacking, had sufficiently attended to those differences as opposed to adopting a party-directed approach. and he was concerned that there weren't agreed common workings to enable him to look at this in detail. So he approaches it in a far more broad brush manner. His starting point, as you'll see, is a point he makes that many of the licenses have a 5-year term, and he says it's sensible to allow, to assume...
His starting point is to ignore the time value of money. Are you defending that as a starting point?
No. I see that, and of course he does. Yes, that's true.
And do you defend that?
As a simplifying assumption, in this case, I say it's one that he was entitled to make. Yes.
Really? Right.
Well, so my lord.
And in what rational world does one ignore the time value of money?
Well, my lord, the point here is that what he is seeking to do throughout this exercise is to make a series of assumptions which are simplifying. He has in numerous respects made assumptions which are favourable to the licensor along the way. So we just saw one of them where he simply bumps up a value here, he gets his 2.63 million, let's call it 2.7 and so forth. All he's seeking to do, because your lordship's completely right, of course, if one is looking at this with ferocious scrutiny, one would take into account the time value of money. He doesn't do that. What he is seeking to do throughout this exercise at this point is approach things on an extremely broad brush basis. That's his approach. And as I've said, I'll come back in a moment to one aspect of this, which certainly falls into that category, which is an assumption that many of the licenses have a 5-year term, and it's sensible for him to assume a period of past release of around 5 years.
Does he actually say that?
He says that. He says that. I'll come back to it. But if you flip backward in the judgment, that's something he says at 4.6. What is it? 465 Roman page 472 at Roman 7. About halfway down the page by the first hole punch. Do you see the last sentence? Given that most licenses have a 5-year term and either a 5-year release period or an assumed period of this duration. That is, he's talking there about,
But he doesn't actually put forward that as a justification in 485.
No, he doesn't. No. To an extent, you're quite right. I mean, I'm gathering this together to try to interpret the judge's reasoning in this part of the judgment. So, on this footing, you see in 485 that he's asking himself, I would expect against that context there to be a 50-50 split, and he says to himself, is there a reliable basis of some kind to depart from that and split my 2.7 billion lump sum in a different way? And he knows
that the evidence that he's got suggests it's wrong, and then he says that he's not prepared to move from his 50-50 split despite that evidence. And what he goes on to say is 50-50 is called for, and this best disincentivise holdout, which is exactly the wrong way around, isn't it? Because what he's doing there is confusing what has happened historically with what you do when you're setting the Fran rate.
So, taking those 2 points in turn, I'll try to develop it in a moment. He does say that that piece of evidence is unprincipled and very evidentially dubious. And I'll come to that because my submission, he's right about that.
And he supplements that in the footnote by saying there was a great deal of evidence suggesting that past releases were valued differently.
He does say that too, yes.
So on the figures we've got, you get a completely different split, and he recognises he's got a great deal of evidence to suggest that 50-50 is wrong.
Well, there is a tension between him saying 50-50 and that footnote referring to the great deal of evidence. The best way that I can reconcile that is to say that that too needs to be put in the context of the evidence as a whole that was before him, which I will come to in a moment, because my first point in answer to my Lord Justice Arnold's absolutely correct intervention is that he is saying that I don't think that this piece of evidence, which was a split between a ratio of a simple release and a free release approach that one of the experts was relying on, is helpful. And what I'm going to do is show you some of the other evidence before him, because it is quite true that he doesn't recite here a basis for saying that 50-50 is a reasonable place for him to stay with. But I want to give you some evidence in support of that finding.
Just before you do, on the disincentivizing holdout, my lord says, well, that he's got it wrong, but is it of any relevance at all? Why should one work out what the friend, how to interpret the past licenses by what would disincentivize holdout?
My Lord Justice Arnold's completely right about that. He was, in my submission, though, doing something different from what Mr. Speck's saying on behalf of Optis. We read that as him commenting on the fact that the 50-50, which, I mean, if you look at the language he uses, and apologies because at this stage I am actually treating his wording with a greater degree of attention than I have done elsewhere, but he says about 7 lines up, having considered all the evidence. Do you see that? About 7 lines up in 485. Having considered all the evidence, and in particular the point that past releases should not be undervalued, I'm not going to move. So my submission is that, I'll come to it, he is aware of a body of evidence that supports him taking this approach. And although I fully see that he's referring to this normative point, that is something which is a comment, by the way. It is not the basis, the case against me, for him arriving at the figure he does. So, he is noting that back in his table 10, he'd set out the estimates from Mr. Besant of the ad valorem rate under each licence, and he'd adjusted it from its stack share to get a 1%. And if you go to page 473, after he'd done his own tweaking of Mr. Besant's simple release and free release numbers, the penultimate row, and it's in blue, shows you the numbers that Optis was pointing to say that you must adopt a different ratio than your 50-50. You see that in the penultimate row under Apple's ad valorem average rate for a 1% stack share. And what that means is that if you take the average consideration, if you spread it over the future licence term alone and forget the past, you get the number on the right. And if you spread it over a period which in the case of many of these licences is assumed to be 5 years back on a sort of straight basis without discounting, then just a longer period, you get the number on the left. And that is the point that the judge is rejecting as not helpful to his determination of whether he should move from a 50-50 split. So I'm focusing here only on this particular piece of evidence. And I pause just to say he was right to do so. And that is because, as the court will appreciate, this ratio doesn't tell you anything about an important question, which is discounting for the past. Because in the way that it's been constructed, which is just saying I'm going to assume a sort of straight additional number of years for the past of 5 years in many cases, you're really making you're showing something which is a function of the assumed length of past and future years in the licence, but nothing more than that. And you can test that very simply, because imagine if you do have 5 years going back and 5 years forward. Assume any values you like for what's for the past and what's for the future. 1 for the 5 years for the past, 100 for the future, whatever, or reverse it. In either case, using this methodology, free release means you take the total and you divide by 5, which is the future-looking term. The simple release means you take the total and you divide by 10, So by design, you're just going to get something which is, in that case, 1/2 of the other figure. So the judge was right to say that this ratio is not helpful in this case. And the point that we
And that's because it's an average, and it's an average of things which are like what you just said, and other things which aren't like that at all.
was it an average?
The reason it's like that
Yes.
is because it is an average. The figure that you're submitting is not useful
Yes.
because it's an average of data which includes some which are like what you've just said, and others which are nothing like it.
Yes. Yes. No, absolutely, my lord. And one important point on this, which we make in our skeleton, I haven't quite got the reference, is in relation to Qualcomm. Thank you. Paragraph 145, page 187 of our skeleton. Yes, actually, if we can turn that up. This is a party now familiar discussion in the courtroom, and if you look on page 187, about eight lines up, you'll see that license. Well, actually, I can mention which license it is. It's Qualcomm, and what he does in relation to that one, for instance, is there's a part of the consideration, again, which is now not taken into account by Mr. Bezant. And he's looking at this, therefore, in a way, if you look at the Qualcomm figures in the table, look at page 471, Qualcomm is about 2/3 of the way down. I can't read them out. But you've got literally the identical figure in the one column and in the other, which is not, therefore, essentially a result of taking a large lump sum value and spreading it over a different number of years at all. It's, in that case, something rather different. So essentially,
It's not the only one, is it? There's quite a few in this table that are like that.
yes, in this table, there are different explanations for some of them, but that's right. So the judge is looking at this and he says, well, look, for what I'm trying to do now, this metric is not helping me. But I come back to, therefore, the point, which is the judge's general statement in 485.
Just before you do,
Yeah.
showing I haven't probably kept up. In terms of the ratio that he says is suggested by table 10,
Yes. That's the one, foot of 473.
and
It's the penultimate row. I wish I could read it out.
yes, no, don't worry.
Yeah, thank you very much. I can use the last digits. The first one ends with an 8, the second ends with a 2. Good point.
The
Yes.
point is those two numbers are in the same ratio as is expressed in paragraph 485.
That's correct.
Yes.
That's correct. And the point that the judge is rejecting is he says, well, this is said to be important to me in my decision about how much to discount.
And
I don't
sorry.
find this helpful.
just so I understand, with some of these licenses, we see unchanged figures from S to FR.
Yes.
Have those been taken into account in calculating the ratio?
They all feed into that ratio. Yes.
Yes, I see.
Ah, yes. Sorry. Miss Love reminds me. That is right, but remember that that ratio at the bottom is only for the Apple licenses. So where
we exclude all the ones where it is unchanged from.
well, that's not all of them. So Qualcomm, for example, is an Apple license, and that's been dealt with in that way. The reason why those ones that I think your lordship has in mind aren't the Optis ones. Those were on a running royalty basis, so it didn't matter.
So they're not fed into the ratio that we see.
No, those aren't, only the Apple ones.
Yeah.
Now, my lord, a quick stock take. I notice I'm now at the time when
Mercer is going to
Mr. Nicholson is going to have at me with the scissors. Nonetheless, if the court will permit me, I am going to finish this point. This is a very important ground to cover. I'm going to briefly cover ground 25 and briefly cover the non-royalty terms residue of the points that I said I would, and aim to finish within the next 14 or so minutes, if I may. So, what the judge says is that having considered all the evidence, and in particular this point about not undervaluing, where we each give different weight to what he means, he's not going to move. So, the first question is, was there a proper factual basis for the judge to say what he did about having considered all the evidence? This is why I'm sticking with this. And that issue in itself has got two aspects to it. The first is, look at these 18 Apple comparables. How was the past treated in terms of compensation compared to the future term on a per unit basis? How was it done? And second, how does the length of the past terms compare to the future license terms, taking into account volumes 2? And obviously the judge is dealing with this at a higher level than individual licenses. Now, on that first question, how was the past treated in terms of compensation compared to the future, the judge did receive direct witness evidence from Apple's main negotiator, which was tested in court. And, moreover, that witness, Miss Heather Muse, did answer questions about Apple and its practice of discounting for past releases. She was important in this context because she was responsible, in the interest of time I won't give you the reference, but she says in her statement, her first statement, that she was responsible for negotiating 13 out of these 18 licenses. Her evidence, which was based on her practice and experience, was that Apple does not discount past sales in these negotiations. And I ought to show you that. That is in supplemental 1 at tab 21, page 270. I'm sorry. I see. Yes. So I'm reminded I should have said alleged practice. If you go to page 270 and you look at the top right side, which is page 680, there's a very short bit of questioning. Begins at line 21, top right, page 680. Typical effects we may see is the writing off of past sales, either for free or at heavily reduced rates. Yes. Answer, that's actually not our approach. We certainly do believe that there are limits and there should be consequences for the past. If, for example, the licensor is delaying themselves, but we don't take a view that past sales are discounted. Question, you're asserting that position even before his lordship today. In what way? In your skeleton argument, you are asking for a discount for the past. No, I mean we are actually giving a bonus for the past, and that is what I was saying. You get interest on those payments, and there is a discount for the future because you're paying today. So her evidence there, based on her experience, was that there wasn't a discount on a per unit basis, at any rate, for past sales. And that is evidence that applied to the majority of the comparables.
Does that word as I read the answer the witness gives at line 8, it sounds like she understood the question which asked for a discount in relating to a net present value type discount rather than a discount of the royalty rate. That's why her answer is an answer to that, because it says no, we give a bonus, that's interest, and there's a discount for the future. That's not addressing the question of whether the royalty relating to a past sale is discounted relative to a royalty rate, is it?
Well, I take that point. She's answering the question, which is about the writing off of past sales, either for free or at a heavily reduced rate. And she is rejecting that. And then you're quite right, my lord. She does go on to express it in the way that you have said.
Yeah.
So that was that piece of witness evidence. There was also in court too, which the judge will have had in mind, an argument about an important, very important individual licence as illustrative of this theme. Mr. Speck did refer to that in his address, and that was where he said Apple was putting forward the proposition that it paid more per unit for the past than the future. That was what it was said to show. With respect, that was not a correct interpretation of the evidence. The witness evidence, the written evidence on that is in Supplemental 5, tab 17. Pages 66 and 67. So at least on my copy, I can tell you which license we're talking about, which is Ericsson. But what I can't tell you is the detail. So if you look for yourself at 37, I'm pretty sure I can say that on the one hand, Optis is saying that there's a large lump sum license. The amount of value for the past, you see from the second and third lines, is a smaller amount of that total number. And then the witness is dealing with that on the facing page at 38. And perhaps in view of the time, if you just pick that up from about 2/3 of the way down, under a sentence that begins, the release was also much broader.
Shall we read that, the balance?
Yeah, from the release was much broader to the end. There's really only 2 points here, because it doesn't need close forensic attention, certainly now. The first is that she's pointing out that as Apple saw it, you're talking about a very different sum attributable to the past, and you can see the relationship that bore to the total amount. The second point, which bears on Mr. Speck's observation on whenever it was, Wednesday, I think, is that the release here is a very broad release covering lots of things and extending back a long period. And the calculation to say that on a per unit basis it amounted to a premium was certainly a submission put by Optis. It was one that is contested because it wasn't taking into account all of the things going into the past. So that was the written evidence on that. For your note, it then became a feature of the skeleton exchanges too in closing, and I'll give you that reference without taking you to it. It's Supplemental 5, tab 6, page 27. I'm sorry, it's our opening skeleton for the trial. So that's the first aspect of the problem about discounting for the past and what the judge actually saw before him, because he doesn't refer to anything particular at paragraph 485. On the second aspect of the problem, what was the length of the term for the past compared with the future? My Lord Justice Newey asked me about that. I referred you to paragraph 4657 on page 472. That was where the judge says at the end, most licenses have a 5-year term and either a 5-year release period or an assumed period. Now, Mr. Speck says, well, that's not right. It is absolutely true that you do not see all or the vast majority of the licenses having a future term of 5 years. What you do see is, as we pointed out in our case, that the majority, that the largest number of those licenses is for 5 or 6 years, and that if you, if the judge was to look to the table to the left of that, many of those licenses, and I shan't go into the detail, but you can correlate it by looking at table 10. Many of the licenses, including for some of the big licensees, I shall not read up from the bottom, those were for 5 years. Equally, it was Optis's case and their experts' case that going 5 years back in the past was a reasonable basis for him to adopt based on the factual evidence that he had and the licensing evidence of their expert, Mr. Starzik. And we gave the reference for that too. I'll simply give you the reference, Supplemental Volume 2, tab 43, page 295. So those are the pieces. That is, as far as we are able to do, the evidential basis that supports the judge staying with the 50-50. Now, what I do need to do is to address the remote possibility that the court is against me on this point, and look at what Optis say about correcting for this feature. Because if the judge did fall into error on ground 9, and if this court does think that contrary to my submissions, he should have approached it in a different way, there is in fact a simple way to do it, which does not involve tearing up the judge's methodology and embarking on an entire new exercise based on a range of disputed expert unpacking evidence, which is what Optis is advocating. And may I say, it is also an approach that Optis cannot complain about. If you look at their skeleton, you can see it very quickly. Go in their skeleton to page 90. This is the part of their skeleton where they're talking about ways of correcting for what the judge has got wrong here. And at one end, they say, well, look, if you make no allowance for a pass release at all, you get a free release number. And if you look at paragraph 129A, you get figures at the top of what is page 91. And they say that, and this is entirely, so this is their workings, and I'm not defending the underlying numbers, I just want to show you the proportions. They say on a free release basis, looking at either Mr. Besant or Mr. Besant or Miss Guttridge, you get figures of between 0.13 cents and 12 cents, or scaling up to lump sum amounts of $334 million or $308 million. That's on the free release basis. And then if you go back a page to paragraph 128, you have what they say in their skeleton is the only evidence before this court about the right thing to take into account. They talk about Mr. Besant having tried to look into this himself as their expert, and him having done his own calculations on what they called an adjusted per unit rate basis, or what they called in the second line of 128 a simple 50% discount basis, which is just, let's just say half of the past is discounted each year. But their case is, well, he's run the numbers on that, and that leads to a figure, which you see at the end of 128, of $1 per unit value of 8 cents, and that scales up to a lump sum royalty there of 205 million. Now, I stress we're disputing all the underlying assumptions, but if this court did take the view that it's appropriate to move away from the judge, and you're asking yourself, well, what material do we have if we were going to correct it? You can straight away see one way of doing it, which is you compare Mr. Besant's rate for his adjusted basis, which was the 8 cents, against his free release basis, which is the 13 cents. So that's based on, it's taking everything he's done, and without looking under the bonnet, you see that the first of those is 8 over 13. It's roughly 2/3, or just under 2/3 of the second. And that means that using the ratios which are implied by his own rates, you're talking about moving from 50-50 to around 2/3, 1/3. And what I should therefore stress is here I'm taking essentially everything that he does at face value, and because those are a range of assumptions based in Optis's favour, that should be treated also by the court, were you interested in that approach, as an upper bound. And what it would mean is that if you go back to the judge's approach, and without doing the maths given the time, if you take his rate of, I think it was 5.13 million a year, and you forget about the point that we're not taking, that he should have gone all the way back to what Optis wants, which is 2013, you arrive at a total number of about $100 million, which is owing, thereabouts, maybe a little bit more. Their figures, though, as you see from these paragraphs, for free release sit around $300 million, so 3 times as much. And we're saying that that is, you can see on that basis, quite inappropriate. If you take what the judge has done and you accept the methodology so far, then you should be working to his lower range for where the judge says essentially a free release basis takes you, which is in the order of about $100 million, not the 300 plus million that is talked about on the other side. And you would adopt the kind of discounting for the past on the basis that I have approached it, because that is the available evidence. So I'm now absolutely in penalty time. If I may, I'll be incredibly quick and then finish on grounds 25 and the non-royalty terms. Ground 25 is the anchoring complaint. They say the judge had his maths corrected and tried to get back to the figure that he'd first thought of. They rely on 5 changes that were made between the draft judgment and the final judgment. In oral submissions, Mr. Speck referred to 3 of those, and he was running out of time as well. Those were B, D, and E. I will do likewise, and by B, D, and E, I mean if you go to his skeleton, this is in paragraph 263, which begins on page 123 of the bundle, and he focused on those 3. I'll deal with them in just a couple of moments. To frame them, we do respectfully put forward the basic principle that the court should adopt when considering how one takes into account a draft embargo judgment, which is the question to ask yourselves is whether the judgment handed down is wrong on its merits. That is the proposition that was made in perfectly clear terms in Robertson and Fernsby by Lord Justice May and Lord Justice Mance in particular, and the references in our skeleton. What you don't do is pass a draft judgment with the kind of attention that you've seen in this case and compare it with the final one to speculate about the judge's motives for making changes if the changes on their merits are reasonable changes. It perhaps falls to be observed that if one imagines if that approach was endorsed by this court as a general matter, that could open the floodgates to a whole new category of appeals to the Court of Appeal. So we say that on inspection, none of these 5 points relied on by Optis, if they're taken individually or cumulatively, are unreasonable. To take the 3 that Mr. Speck referred to, complaint B, which is top of page 124 of the skeleton, that was about Qualcomm and the change that was made there. I've already covered it last week. The main point is that in the draft, the judge on balance decided to keep Qualcomm because he thought the impact of it, wrongly, was a lot smaller than it actually was. He then sees the full scale of the distortion and he acts on it. But that's not bias. Complaint D was the judge's decision to divide the price of the stack to Apple in half, what we've just been talking about. The point that they make is, well, look, we now show him the correct ratio, not 50-50, but according to Mr. Bizant, the other ratio that we were just talking about came out of the table, comparing simple release and free release numbers. They say, well, the judge should then have gone by that information. For the reasons I've given, that's not useful information in this context. The judge didn't need to do so. And complaint E is the fact that the judge ran a form of cross-check in the draft judgment when he was considering the worth of the Optis comparables. You know, what if Optis had 1%? What if they had 2% of the stack? He doesn't pursue that in the final judgment. They say, well, that's sinister. It's not sinister. It's perfectly reasonable to drop what's a speculative cross-check, which the judge himself says in the draft judgment is based on absolutely no evidence, and which on his reasoning in the final judgment doesn't show anything useful, because he criticises the use Optis seeks to make of it, relying on headline rates that their experts said were the top-down appropriate rates. And he says no, transaction rates are the important thing to have regard to. So that's all I say about that ground, ground 25. Non-royalty issues, we've cleared that away, I hope, because of the approach that I indicated last week. We're not opposing working off the composite draft license that was presented to the trial judge. So we don't need to argue about the judge's streamlined version. There are just two issues which this court will need, we say, to address. One is substance, one is process. The substance one I'll deal with as quickly as I can. It should take 3 minutes. And that is ground 17 of Optis's appeal. That is where they say, well, the judge made a startling decision because he says interest runs on the amount that's due to them only up to the 1st of January 2023, which was the date he chose for the effective commencement date of the license. They say, well, that can't be right because it's common sense, it's principle that you pay someone who's been kept out of their money until they receive the money. There's an end of it. It's necessary to have a full picture. The part of the judgment concerned is paragraph 502 on page 495. Essentially, the judge says the amount of money that should have been paid over. Right at the end, below Romans 1, 2 and 3, he makes a general comment, I've heard only limited submissions on interest, and the above represents a firm but provisional view. Part of that is his view from 501, 3 lines up, where he is referring to the forward-looking licence commencing 1st of January 2023, and the implication that interest only runs until that date. We say, as a matter of observation, it's plain that that statement of the judge, I've heard only limited submissions about interest, was talking generally, including about the date. And he might have expected submissions on that. Now, Optis didn't make submissions on that. They appealed on that basis. Now, we hear certainly what my Lord Justice Arnold said about that and procedural rights. We are where we are. We're before the Court of Appeal, and the question is whether what he's done is correct.
So you're not arguing that they've waived their procedural rights?
We're not arguing that, my Lord. But what we do say is that the real point is that you should look at the judge's decision on interest in the round, because there's a dimension here that this court does need to bear in mind, because there are two things at work. There's the interest stop date, which takes you to the 1st of January 2023. And then there's the point that the judge explains, and you need Core Bundle 2, that he's deliberately going to choose a rate of interest which is higher than the commercial borrowing rate, to ensure that the party that needs payment is properly compensated. And what he says is, I'm going to choose an aggressive rate, essentially because of, this is a Fran case, I want to disincentivise holdout. And he does that, core 2, page 34, at Romans 6 and Romans 7, the bottom of the page. So what he says there is, I mean, he's got his rate, which no one at that point is contesting his date of the 1st of January 2023. But now what he says is, I'm going to choose an aggressive rate. And if you look at the footnote in particular, he castigates Mr. Trenton on our side for having put forward a commercial rate that's due. And he says, no, I don't want a commercial rate. I want to incentivise faster negotiations, disincentivise holdout. And our point there is that one needs to take this together, because although the rate runs all the way until the 1st of January 2023, even any theoretical possibility of holdout by Apple stops when the matter comes into the hands of the court for the Fran determination. Also, a point that I was making last week...
That seems to be rewriting history, notably in Trial F, but go on.
I hope that this next point will find more favour, which is that there's been no suggestion as regards Apple, where he looks at the behaviour in the negotiations. I showed you that bit of any delaying tactics by Apple, either in the proceedings or in relation to the negotiations that led to this litigation. And you'll recall in one paragraph I showed you that the judge actually finds A, that Apple has negotiated properly, and B, it's the counterparty whose conduct was, in the judge's words, in material part, the reason to achieve a negotiated outcome. That was paragraph 354 at the top of page 419. So our point very quickly is that putting that together, there's no justification for applying interest against Apple at the disincentivising holdout rate more than the commercial rate of 6% compound, certainly, we say, beyond the date of the position statements, or at latest the trial itself in June 2022, but the judge awards interest against Apple at that aggressive rate beyond that to January 2023. So that is why we say, if one is considering the judge's decision and one is taking into account the principle that one is about protecting somebody who needs to be given something to compensate them, those two dimensions both do feed in. For completeness, the court does need to be aware that the judge doesn't leave it there, because in his order, which is paragraph 5, he does require money to be paid into court, and interest is then payable on it. That payment happens in March 2024. So what one's talking about is a period between March 2023 and March 2024. You've got the fact that the judge has applied a deliberately aggressive rate of interest to Apple for broadly a full year longer than we say that would have been justified by the principle of deterring holdout by Apple on any view. That should weigh in this court's determination, if you're considering this, about how the interest burden falls. Last point, 2 minutes, the point of process in settling the non-money terms of the court-determined licence. We foreshadowed that before. Optis says if you've got a debate before you about whether to include terms about things like material breach in a court-determined licence, the way you do it is to look at what the licensor says we want in the licence. You, the court, then ask yourselves, do I consider what they're saying is FRAND or not? And it's only if you say what they're saying isn't that you reject it. And by the way, you must also look only at the position of a hypothetical party and not the party to this dispute. So that's their position. Ours is that, as I indicated at the end of last week, the right approach is not to consider a wholly abstract problem. The court doesn't confine itself to considering terms divorced from the commercial reality of the situation in front of it. Were you, for example, to have a SEP owner which didn't like the result that the court was coming up with, and was keen to find a way of commencing litigation on some basis to get out of the agreement, that would be something for the court to bear in mind. A willing licensee or willing licensor, if it saw it had a counterparty with that sort of mindset, would agree that the court should take it into account if that was the case. My Lord, I apologise because I'm now 16 minutes over time. Unless I can assist you further, those are my submissions.
Thank you very much, Mr. Turner. Mr. Bass.
Well, I'll start with a few words introduction, followed by a roadmap to give your lordships the route I'm going to take. But what we say about both of these grounds, but in particular ground 23, is that the essence of the grounds is buyer's remorse. Optis invoked the jurisdiction of the English court expressly on the basis that the parallel US proceedings were being pursued on a contingent basis. That's MOS 2, and we'll go to that. So from trial E, the logical inference from the facts we will submit, after going to them of course, is that Optis made a deliberate tactical call not to rely on the US jury award of $300 million as evidence of value. We say, no doubt, perhaps because it hoped to do better by approximately one order of magnitude in this court. So in short, Optis, we say, gambled on a much higher royalty award and reliance on 300 million for what seems to be an important part of the portfolio might have risked anchoring the judge at too low a figure if it were used as an indicator of the overall value. And what we see in Optis' skeleton in this appeal is transparently an attempt to rely on the US award as evidence of value, the cross-check, the flaw. Now, final word in introduction is that there was one limited basis for which Optis invoked the US judgment as going to value, and this was as evidence of litigation success. Therefore, that went to the better than average point, which the judge ultimately rejected in 182 of the main judgment. But what's important perhaps about that, we would say, is that evidently on the other side of the court, my own friends thought about this US judgment issue, and they decided to bring it in a particular limited way. So my roadmap, I'm dealing with grounds 22 to 24. I'm going to start with 23, then go to 22, then go to 24, because 22 is the procedural aspect, the alleged procedural unfairness in relation to paragraph 6.2 of the final order, and 24 is about 6.2 itself. On ground 23, I need to go back to, although your lordships, I'm sure, know the Supreme Court decision in Unwired Planet much better than I do, I need to go back to a few paragraphs, which I think to make 2 points there. But the second thing I will do is to go to the facts, and I will, particularly on the UK part of the proceedings, need to turn up a certain number of documents. Then I'll go to the paragraphs of the judgment which are relevant and the nature of Optis' criticisms. Fourthly, I'll go to the evidential difficulties if the US judgment came in now for the first time. Fifthly, I'll deal with Optis' reliance on post-trial correspondence. Sixthly, I'll deal with Optis' point about the judge's treatment of Ericsson patents was different and preferential to Apple in a way that he should have done the same thing for the US judgment. And finally, a few words in conclusion. So if we can take, my lords, the authorities bundle 4, and while your lordships are getting that out, I'm going to be stressing that the jurisdiction being exercised, the friend jurisdiction, is a contractual jurisdiction. That's really important when you're concerned with conflicts aspects. And also the fact that the Supreme Court specifically foresaw how to carve out foreign proceedings. And so the judge, we say, on the basis of this, was correct not to let Optis continue in the United States. So I turn it's Appendix Bundle 4, at tab 3, and I start at paragraph 58 in the judgment. (58B) to be precise. It's on page 283. So the submission set out, we recognise, as is undisputed, that in B, in the absence of the IPR policy, the English court could not determine a FRAND licence of portfolio of patents which included foreign patents. It's the contractual arrangement which ETSI has created in its IPR policy which gives the court jurisdiction to determine a FRAND licence which lies at the heart of these appeals. And the court comes back to that in paragraph 90 later. But just before going to 90, I should pick up as I go through, well, perhaps paragraph 71 on page 287, because it's part of the source of the Supreme Court's inspiration is the Ninth Circuit decision of Judge Berzon in Microsoft against Motorola in 71. Judge Berzon explained that the US courts have jurisdiction in a contract action, i.e. an action to enforce, sorry, I'm taking this quickly, but the previous paragraph gives a bit more of an outline, deals with the first instance judgment, but it's the appellate judgment which was of particular interest to the Supreme Court. The courts have jurisdiction in a contract action, i.e. an action to enforce the obligation on the SEP owner to grant a RAND licence and therefore not to enforce its patents. To grant an anti-suit injunction against enforcement of foreign patents covered by the contractual obligation. She observed, when that contract is enforced by a US court is not enforcing German patent law, but rather the private law of the contract between the parties. Although patents themselves are not extraterritorial, there's no reason a party may not freely agree to reservations or limitations on rights that it would have under foreign patent law in a contract enforceable in the US courts. And then to 90, on page 293, the beginning of 90, the court there recites Huawei's submission about the risks of forum shopping, conflicting judgments and applications for anti-suit injunctions, and then talks about the fact that the real defect, I think picked up, if I'm not mistaken, by two of my lordships on Friday in the Lenovo against Ericsson. The problem here is the absence of an international tribunal to deal with these FRAND issues. And so it's then particularly important over the page. In the final analysis, the implementers and the SEP owners in these appeals are inviting a national court under current policy to rule upon and enforce the contracts into which the SEP owners have entered. And so, just jumping to the next sentence, the English courts have jurisdiction to rule upon whether the UK patents in suit are valid, have been infringed, and also have jurisdiction to rule on the contractual defence relied upon by the implementers based on the true meaning and effect of the irrevocable undertaking the SEP owners have given pursuant to the ETSI regime. I'll come back to a couple more paragraphs in a moment, but just on this. So this is really important, we say juridically, as to the task which is being carried out. When one's considering questions of interim relief, questions of anti-suit injunctions, and so on and so forth, to hold a ring pending some event happening, that's one thing. But on the other side of totally different, is the contractual jurisdiction. So it's perhaps as if an English party and an Australian party agree to exploit a mine in Australia, and the A is to exploit the B's mine in Australia, and the contract provides that it will be mined for tin, but if they find something else, they'll endeavour to agree. If they fail to agree, that matter, that disagreement, will be submitted exclusively to the English courts. So when they mine tin for a few years, then they find copper. They come to the English, and they don't agree. They come to the English courts and they say, please interpret this contract for us. How should we deal with this? And the parameters of the contract. It's difficult, but the courts have done this. And when that judgment of the English court arrives in Australia, there's no sense in which there's a usurping the jurisdiction, simply applying the contract. So we say that's fundamental. We say that it's unfortunate that Mr. Speck developed his arguments in relation to both 23 and 24 in the same way, as part of the same together, because they are separate. And they are analytically separate and must be kept separate, because otherwise one ends up talking about anti-suit relief and comity in the context of a contract exercising contractual jurisdiction. So we say then, but then the next question, which I need this judgment for, is what is the mechanism, if any, if you want to have, on the one hand, a global FRAND determination from the English courts, but on the other hand, to maintain proceedings for a part of the portfolio in another jurisdiction. And we say that paragraph 64 to 65 in Unwired Climate are helpful on this. This starts at the bottom of 285. Well, it's really 265. So it's talking about, it's a particular context. I take the point, it's not the same context as this. But nevertheless, it's talking about what I submit is logically the same issue, which is how you can have two sets of proceedings continuing at the same time where there's necessarily an overlap. And so at the beginning of 64, we agree with the parties the FRAND obligation extends the fairness of the process, again picked up in Panasonic and by my lordships in Lenovo and Ericsson on Friday. So that's the process. But if an implementer is concerned about the validity and infringement of particularly significant patents or a group of patents in a particular jurisdiction, which might have a significant effect on the royalties which you have to pay, it might, in our view, be reasonable for the implementer to reserve the right to challenge those patents or a sample of those patents in the foreign court. It might also be fair and reasonable for the implementer to seek to include in the license an entitlement to recover sums, a sort of clawback mechanism. And so the example lower down, if I can pick it up about 5 lines up from the bottom, for example, in the conversant case, it might well be argued by Huawei or ZTE at trial, and that's important, my lords, that the obligation of fairness and reasonableness required any global license by conversant to include provision to allow for Huawei or ZTE to seek to test the validity and infringement of samples of conversant's patents with the possibility of consequential adjustment of royalty rates, given the importance of China. And then 65 gives a little more meat to the skeleton on this. In the unwired case, Huawei appears not to have sought any provision in the draft global license to alter the royalties payable if Unwired's Chinese patents or relevant sample were successfully challenged. And so there's no adjustment mechanism in this contract, no appeal on the terms. That notwithstanding, says the court, it would be open to Huawei in another case to seek to make such a reservation when negotiating or debating in court the terms of a license, to seek to persuade the court at first instance that a reservation was appropriate in a FRAND process. And so we say, stress the court at first instance that the reservation was appropriate in a FRAND process. Because really what we are dealing with here is who is in the driving seat for this? Is this the parties who decide, right, I'll get what I can in the UK, but actually I've got these good proceedings in Texas, I just keep those going, and I'll try and I'll see when I get to the end of the process, after the UK license has been granted or determined, the terms have been determined, certainly the royalty term has been determined, I'll then argue about the interface between the two.
I don't think the court was getting into burden, if that's what you're getting at, but certainly in what they're talking about here is the implementer making a reservation about challenging foreign patents.
Lord, indeed, and I don't shrink from the fact the context is different, but nevertheless, the process, we say in principle, must be the correct process, whether it's the implementer or whether it's the licensor, the set holder, who is seeking to, in a sense, make a reservation. Because what my learned friend was asked by your lordship, Lord Justice Arnold, so you asked for a single determination, and he accepted that with alacrity. And so it's that single determination. If you're seeking a single global determination in the English courts, what is the relevance any longer of the proceedings in Texas?
Is that going to be a
That is a convenient moment.
2 o'clock.
We did say lunch,